who are asserting that the General Court Martial, as we knew it before, still exists. If they are lawyers, they are novices. If they are politicians, they are disingenuous. The judgment was unequivocal, was very, very clear. The Constitution created a single-lane judicial system. No, never did they suggest, the members of the Constituent Assembly, that Uganda shall have a dual criminal justice system. No, it's a single lane. Now we have been having a system whereby there are two sets of courts. You have the conventional courts, and you have those who sit at Machindi. And they pronounce themselves very clearly on this. That was never the intention of the framers or the progenitors of the Constitution. In as much as they recognized the historical significance or importance of a general court martial in instilling discipline within the military force, when it came to dispensation of justice, the justices were very, very clear on this. So, Parliament exceeded its mandate in enacting the UPDF Act in 2005 by creating two things. One, the provision, that is 117, which is now 119, that vested mandate in the General Court Martial to try civilians of two categories. Those who were said to have brought themselves within the purview of the General Court Martial by either abetting crimes committed by serving military officers, or those who wielded weapons which had been considered the monopoly of the UPDF. Now, that animal, we asked when we were in the General Court Martial, that animal, a weapon which is ordinarily the monopoly of the UPDF, which one is that? It was the same question before the Supreme Court. Which one? It has never been defined. So in other words, there is no weapon which is a monopoly of the UPDF. And that's where Parliament went wrong. They also went wrong in that suggestion that even soldiers who are charged with capital offenses that attract serious and grave penalties like a death sentence or life imprisonment, that they can be tried by a tribunal which was not competent, manned or presided over by people who did not have necessary qualifications. So that's why they had to nullify Section 197 of the UPDF Act, which created the General Court Martial and never defined the qualifications for the members of the General Court Martial, save for the chairman, whom they said shall be at the rank of Lieutenant Colonel. But Lieutenant Colonel, of what qualifications? You can be a Lieutenant Colonel, but not a lawyer. You can be a medical doctor, you can be anything. But as long as you are Lieutenant Colonel, that you could qualify to be the chairman of the court. And also, so, in other words, there are systemic problems or defects within the system which the justices faulted. So, in a nutshell, the point I am driving at is that the General Court Martial was disbanded because the provision that created it, Section 197 of the UPDF Act, was nullified. So, as we speak today, there is no General Court Martial. So if in your speak or in your talk, you refer to that outfit, the residue of it, as a general court martial, your statement would be unconstitutional. It would be actually, it would amount to contempt of court if you call this so. So from today onwards, please, nobody should be speaking about the general court martial. You can add adjectives as you want. The defunct general court martial, the former general court martial, the whatever, or whatever, the late. So there is no general court martial as of 31st January 2025. That is the new legal regime. That point I wanted also to emphasize it. Now the last one is the issue